Good morning, everybody. I hope you're well. We just wanted to issue an update to you all about the renter reform bill, following on from the presentations that we did last year and how the bill would impact you as landlords and affect your tenancies. As there's been some recent updates on the bill, we're now at the third reading at Parliament and there's a couple of tweaks that have been made to the bill which massively affect the way that tenancies are going to be drawn up in the near future. And the way the bill has been written means that there's some serious implications to landlords today as we stand, rather than just after the bill has actually started. So we're going to talk you through those today. Hopefully everything we're going to go through has made sense or will make sense. If you have any questions, I'll explain to you at the end how you can get in touch with us. So first of all, as I say, the bill has now passed through the third reading in Parliament and has gone to the House of Lords. It's very likely now this will become law before the next election. It was a manifesto pledged by the current government, so the House of Lords can't really get in the way to stop it coming through, and it's likely that the current government are going to want this to be seen before the new election. It may well be changed afterwards. However, as it stands, this is likely to become law this year, given that the election date has been proposed for kind of October, November time. So what will actually happen? So first of all, there'll be a date when the bill becomes law, which, as I've said, is likely to be before the end of this year. But when that bill becomes law, they will then set a commencement date. So that's the date when the bill will actually start. And the reason for that is it will give the market time to prepare. Obviously, there's going to be lots of adjustments needed to tenancy agreements, the referencing process, etc. So it'll be quite similar to how the tenant fee ban worked, whereby there was a law, and then that law had a commencement date, and that gap in between gave the market time to prepare and make any adjustments that were required. Now, it's these dates in particular, and this commencement date, that will have the major impact on your tenancies, but the impact starts from today rather than just from the commencement date. I'm going to explain to you how that works. So when we talked about rental reform last time, one of the key concerns for landlords was that the ability to serve a Section 21 notice, or what's commonly known as a no-fault eviction, was going to be removed. Now, you may have seen in the press that there's been lots of talk about that's not actually going to happen. It's all based around court reform. However, that's not strictly the case. There is still going to be a review of the courts, but that does not mean that Section 21 is being removed from the bill. The way the bill reads is your tenancy will fall into one of three categories at the commencement date. So first of all, you have category A, which is any tenancy drawn up after the commencement date, so after the bill starts. Now, at that point, any tenancy drawn up under that will come under rental reform, and no Section 21 will be available on that tenancy. Category B will be a tenancy which started before the commencement date, but is still in a fixed period which ends after the commencement date. That will also come under rental reform, and no Section 21 will be available. So if we use a hypothetical commencement date of the 1st of September, if your tenant moves in on the 1st of August with a 6-month fixed period, that fixed period would end after the commencement date because it would go past the 1st of September, and therefore that tenancy would come under rental reform. So when they go into a periodic tenancy at the end of the fixed period, you will not be able to use a Section 21. So category A and B will only be able to use the new eviction process, which would be a Section 8, which is whereby you need to offer grounds and state the reason you're asking the tenant to leave, and you will need a court date or the court's assistance with obtaining a possession order. We then have category C, which is a tenancy which started before the commencement date, and at the commencement date is then a periodic tenancy. Now, the way the bill reads at the moment is these are the tenancies which will be captured under the court review, and Section 21 will remain available. So again, if we use that hypothetical commencement date of the 1st of September, if your tenancy started on the 1st of February and it was a 6-month fixed term, your tenant would go on to a periodic tenancy on the 1st of August. So therefore, on the commencement date of 1st of September, your tenant would be in a periodic tenancy. So moving forward, even after the commencement date, you would still be able to serve a Section 21 under the way the bill reads at the moment. Now, just to remind you, the benefit of that, of a Section 21, is that you don't have to give reasons to ask the tenant to leave. You can serve 2 months notice, and you don't need a court date or a hearing in front of a judge in order to obtain possession, assuming that your paperwork is all in order and the tenant doesn't file the defence. Okay, it comes under what's called the accelerated possession procedure. Now, what will happen for those type C tenancies is a backstop date will be set. Now, I'm sure that's a word we all thought we'd heard the end of after Brexit. However, it will be very similar, whereby there will be a backstop date set, which will be based on the review of the courts. Okay. Now, the way the bill is worded is there's no set criteria for what they expect to see from the courts before that backstop date will be lifted. It's basically worded that it comes under the Lord Chancellor's review, and it's at a date where he sees fits. So there's no set criteria for court dates, etc., or court processing times for this backstop date to be lifted. Now, what you would expect is once renter reform comes in, is the courts will get busier and busier, because those landlords with type A and type B tenancies will need to use the courts in order to gain possession. They'll need a hearing, and they'll have to use court assistance to gain a possession order. So the potential is that backstop date could get moved further and further back as the courts get busier and busier. So you could end up, if you have a type C tenancy, in a position where years after renter reform has come in, you could still serve a section 21. Now, in theory, this would create a two-tier rental market where you'll have some tenants on new tenancies where section 21 can't be served, and some tenants on older tenancies where section 21 can still be served. Now, this is not that unusual though. When ASTs were first invented back in 1985, I think it wasn't uncommon for tenants after that date to still be on old rent-at tenancies where they had a tenancy for life. And even still now, you can find tenants on rent-at tenancies. So this two-tier housing market is not unusual, and precedents have already been set for that to exist. So it does make sense that that could still be the case moving forward. But what does all this mean? Well, effectively, with immediate effect, we're advising our landlords not to renew tenancies with current sitting tenants. The reason being, if you do this, you're in danger of moving from a type C tenancy, where you will be able to serve a section 21 after the bill becomes law, to a type B tenancy. So if we go back to our hypothetical commencement date of 1st of September, if you have a tenancy in your property now, and they're on a periodic tenancy, and you give them a new 12-month term via the process of a tenancy renewal, and a commencement date comes in on the 1st of September, you will move from a type C to a type B, and therefore you will lose any ability to serve a section 21, because you'll go into a new fixed period, and that fixed period will end after the commencement date. Okay. Now, at Infinite, we've always felt that renewing tenancies wasn't the best idea for landlords anyway, but we understood that tenants and landlords sometimes like security. We've always felt it was best to be in a periodic tenancy because you can use section 21. Your ability to get your property back is greatly improved by being in a periodic tenancy. But we didn't really discourage it. If landlords and tenants were happy to renew, we were happy to carry out the paperwork and the administration of that. However, what you'll find moving forward is we will actively be discouraging landlords from renewing their tenancy at this point in time due to these potential changes in the rules. Now, you may find other agents don't take the same tactic. Agents can generate large incomes from renewals. However, we just feel at this time it's the best advice for landlords not to renew their tenancy until we get some greater clarity on exactly how this sits and when the bill is going to become law. If you want to still carry out a renewal, absolutely we can do that for you. That's not a problem. We just don't feel it's best advice, and we will ask you to sign a disclaimer to say you understand the reasons for that and the potential dangers of carrying out a renewal at this point in time. Just because you can't carry out a renewal doesn't mean you can't increase rent. You absolutely can do that. You don't need to sign a new tenancy agreement to increase the rent. This can be done via a section 13 notice, as long as you give the tenant the right notice and serve the right paperwork, which we can do for you. But there's no need to sign a new tenancy in order to increase the rent. Now, it may be that this tactic we've taken is overcautious. However, at this point in time, we just don't see the risk in moving from a potential tenancy where you can serve a section 21 into one where you can't. Moving forward, if you're able to serve a section 21, it will make your life a lot easier if you need to get possession of your property back. So we just don't see at the moment the reason why landlords would take that risk. So hopefully that all makes sense. If you have any questions at all, please feel free to email us on info at infinitepropertyltd.com. If you put the subject as rental reform bill, it will go to the person who can answer the questions for you. Feel free to send us any questions that you have and we'll get back to you as soon as we can. Thank you for listening and I hope you all have a great day.